In the last segment, we have seen what is partnership, what is the nature of partnership, definition of partnership, and the characteristics of partnership. We've also done a quiz on these topics. Now let us see what is an illegal association. Now this word illegal we have studied in the Indian Contract Act 1872. What do you mean by illegal? Illegal, in simple words, means something which is against the law. So now this means this word illegal, when it comes with association, makes this association against the law. So what do you mean by the word association? Association means collection of people, some people coming together generally to do business. So when a few people come together to do business, we call them an association. So we can call partnership an association. We can call a company as an association. We can call co-ownership as an association. So when does such an association which is doing business become illegal? Now illegal, I know, is going against law. So there must be some law which says that a particular association is against me, or it breaches some provision of law. So what is the provision of law that makes an association illegal? It is defined in the Indian Companies Act 2013. Now see, we have got an amendment. There was this Companies Act 1956, which is now scrapped, and a new act, Companies Act 2013, has come in. So before the Companies Act 2013, Companies Act 1956 was in existence, and as per that act, any association which is into the business of banking cannot have more than 10 persons, and any association which has more than 20 persons into the business of any business other than banking is an illegal association. So as per Indian Companies Act 1956, it has two things. First, non-banking business. Second, banking business. So for non-banking business, the limit is 20 persons, and for banking business the limit is 10 persons. So the limit is set on the basis of the business. If the business is of banking, the nature is banking, then 10 people are allowed to be in association. So if some people come together and form partnership and do the business of banking, such a partnership firm cannot have more than 10 partners. But if the business is not of banking, let's say they are into manufacturing of paper, or they are into servicing of electronics or selling electronic goods, or they are into selling automobiles. So whatever business they have other than banking, there cannot be more than 20 persons in that partnership. So please remember, as per the old act, the Act of 1956, for banking business, 10 persons are allowed, 10 partners are allowed. If this partnership gets an 11th partner, this will be called as an illegal association, because the law says, actually it said, now it has been scrapped, so we should say the law said any partnership having more than 10 persons doing a banking business will become an illegal association. So the limit set was 10. And for non-banking, any partnership firm having more than 20 partners and doing a non-banking business, any business other than the banking business, it can have only 20 partners. So if it gets in more partners, let's say it gets in 22 partners or 25 partners, such a partnership firm will become an illegal association. So the next question that comes up is, can't we do a business wherein there are 25 people, there are 25 owners, there are 25 members, or 30 members, or 50 owners, 100 owners? The answer is yes, you can always do that business. The only condition is you will have to form a company for that. You know that there can be innumerable owners or members or shareholders in a company. So this limit is set in the Indian Companies Act, and if you do not follow this limit, when you are going against the law, your firm will become an illegal association, an illegal firm. So if you want to induct more partners, if you want to induct more owners, convert your partnership into a company, form a company. So this is what the Indian Companies Act 1956 said. So let us see what does the Indian Companies Act 2013 say. As per Indian Companies Act 2013, what does this act say? It gives only one limit. The maximum number will always be set by it says as prescribed by central government, CG. CG means central government, in the rules that it publishes. See, central government has the right to issue some rules regarding the Indian Companies Act. Such rules are not mentioned in the act, but a right to central government has been given to issue rules. So one such right has been given to central government, that it can set the maximum number of people that a partnership or an association can have, and it can set the limits. However, the limit that it has set is 100 persons. Central government cannot set the limit beyond 100 persons. So it can always set a limit of 50%. That means if a partnership has 50%, then it is okay. If it has 52, 51, 52 or 55, 60 members, 60 partners, then it will become an illegal association. So central government has to issue a maximum number, but that number has to be within 100. If that number is 50, it's okay. If that number is 70, 75, 80, it's okay. But central government cannot go beyond 100. It cannot set a limit of 110 partners in a partnership firm. No. So if the central government sets the limit of 80, that means we can have a firm with 80 partners, but not more than 80 partners. Once the number of partners goes beyond 80, the firm will become an illegal association, and if it wants to continue, it will have to form a company. It cannot continue as a firm now. Okay, so this was about illegal association. The limit set in the Indian Companies Act 2030 is 100%. However, central government by its power can set a lower number, but it cannot exceed 100%. Okay, so now let us take a short quiz on this topic. In case of partnership, maximum number of members in a banking company are A 10, B 20, C 15, D 30 in a banking company. In a banking company, they can be 10. In a non-banking company, in a non-banking business, they can be 20. Okay. When the number of partners in a firm exceeds the number permissible under the Indian Partnership Act 1932, the partnership becomes A. a public limited company, B. a cooperative society, C. an illegal association, D. a private limited company. Now, there's one thing that I'd like to tell you, that the number permissible is not given in the Indian Partnership Act. It is given in the Indian Companies Act. So what happens is, many a times a question is asked as to in which of the following acts is the maximum number of permissible members given for an association. So they'll give you options: Maharashtra Cooperative Societies Act, or UP Value Added Tax Act, or the Indian Companies Act, Indian Partnership Act 1932, or Sale of Goods Act, or Negotiable Instrument, whatever the options may be. So then you'll have to choose the Indian Companies Act. However, this is a past exam question wherein possibly they have mistaken and written Indian Partnership Act in place of Indian Companies Act, because the limit we've already studied, it is given in the Indian Companies Act. So now let us assume that this is Indian Companies Act, and from the given options the answer should be, if the number of partners or members exceeds the maximum permissible limit, then it becomes an illegal association. Okay, so this was about illegal association.